12:30 meeting with the majority leader, I'll go next. Let me, first of all, I have 8 documents, 4 from the insurance industry, 2 from industry, and 2 from expert witnesses. I ask unanimous consent that be made part of the record. Without objection, so ordered.
Without objection.
Mr. Barron, I don't think there's a member of Congress who doesn't agree that the limits that were put in place back during the Exxon Valdez. I happened to be in the House at the time, but I actually went up there. I'm very familiar with the process that took place. But that $75 million is too low. We all understand that, and something needs to be changed, and that's what I made that very clear on the floor when I objected to the Menendez motion on the $10 billion. I think that's arbitrary, and but let me just ask you, and this is going to be kind of hard to answer, but kind of guess with me on this one. If we were to raise that to $10 billion or eliminate the caps altogether, about how many companies roughly would be left to explore and produce in the Gulf?
I'm really not in a position to comment about how many companies would be left. I can say that from an insurance market standpoint, there is not sufficient capacity to provide companies insurance protection to limits which are being proposed.
Well, the big 5, I would contend, and this is what this argument I made on the floor, may be the last ones, along with the national oil companies, if it were raised to $10 billion. Do you strongly disagree with that?
No, I do not.
And BP is one of the big 5. In other words, if we raised it up, I would say this would put them in a more advantageous position than they'd be in today. That's my opinion. If that were raised up there, how many of the independents, just take the next step down below the 5 majors, would be able to purchase insurance to be able to operate?
Well, again, there's not sufficient capacity from the insurance market to meet these proposed limits, and I believe that then you would have to rely on their balance sheets and their ability to demonstrate the financial responsibility test.
Yeah, my concern, the reason for mentioning this is that obviously we want to, I'm one of these few in Congress who believes that in order to run this machine called America, we have to have fossil fuels, and one of the great sources is offshore. I know a lot of them. In fact, we are suppliers in my state of Oklahoma of many who are out there, and it would appear to me that if you were to take the limit, if we were to take the cap altogether off, it could be instituting a de facto ban on offshore drilling. Do you think I'm unreasonable in coming to that conclusion?
No, Senator.
Mr. Hartman, you used a term that I asked the staff, and they weren't. I wasn't familiar with it, and they weren't either. Maybe you could help us out. You said Alternative Funds Act or Fines Act. What were you saying? Would you repeat that?
The Alternative Fines Act is under Title 18 of the U.S. Code, and it gives a court the discretion to fine anyone convicted of a covered crime any amount equal to twice the economic harm caused by the crime or twice the economic gain as a result of the crime. That's been on the books for a number of years. It was the statute that was used in the Exxon case that resulted in a $1.1 billion resolution instead of $25,000 a day, which is what the negligence provision.
Well, that's interesting, and our staff is going to look into that, because as we progress on this thing, that might be a place to be looking. Let me ask you a question that I think it's very basic, and maybe everyone knows the answer but me. Many years ago, I was a claims adjuster. That's what I did for a living. Establishing losses is something that is not an easy thing to do. Under the CRS report, there are 6 categories of economic losses and different types of economic losses and natural resource damages. I put them in those 2 categories because I think that's where this comes in. And I would like to have you kind of tell us, first of all, the relationship between the way the current claims process is operating and the current liability cap. Would this bill as written or any other bill that simply raised or removed the cap altogether have any effect on the claims process?
Well, in partial responses, the chairman made the observation about what happened in Alaska. Of course, that was before OPA was passed, and one of the purposes of the Oil Pollution Act and that process is to provide a quicker and more expeditious claims process and the incentive for people to go into that process, at least in my experience, is that it's easier to prove the damages in that process than it is in court, and you don't have to prove liability that you have to prove in court.
I see. Well,
But of course, that process is only available for claims under OPA. If you expand, if I understand your question, if you expand or make it an unlimited liability amount, I suppose more claims, if there's claims beyond 75 million, could go to that fund. Hopefully, it would create an incentive to make more people go to the fund, and they wouldn't have to wait 20 years for recovery by having to go to court. I don't know if I've answered you.
yeah, you have. And, you know, all the way through this thing, I've been wondering, when they talk about economic damages, that sounds good, that sounds easy, and certainly you folks know what economic damages that you would feel you'd be entitled for some kind of remedy or recovery. But it's not an easy thing to address. It's very complicated. Do you have... Okay, for the record, I'd like to ask you to submit to me some of the complications in determining economic losses as well as natural resources damages. Is that fair? Yeah.
I have no objection.
Okay, good. Thank you very much.
Thanks very much.